Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I provide online divorce, valuation, and mediation services in St. Louis, Missouri. Today, we will discuss divorce finances, tracing marital assets and separate property with Beth Garrett and Bob Boyd. Bob Boyd is a family law attorney in Atlanta, Georgia, and co-founder of Boyd, Collar, Nolen, Tuggle, and Roddenbery. Bob is a leader in family law who has received recognition from his colleagues across Georgia and the nation for his work in high net worth divorce litigation and contested custody cases. Beth Garrett is a lawyer and accountant in Atlanta, Georgia. She's also a partner in the Divorce Litigation Support Practice at Frazier Deeter, primarily assisting high net worth individuals and corporate executives with divorce, tax, and accounting issues. She helps people through mediation and works with divorce lawyers through all financial aspects of litigation and child support matters. She's also a valuation expert and has a credential. Welcome, Beth and Bob. How are you? Another thing that we haven't talked about much, we did talk about the Thomas case having to do with home ownership in Georgia. But what relevance does other case law or, other cases have in the tracing of assets in Georgia specifically? Is there any other case law that you have to look at? Do we even care about case law? I mean, this is a new case. We'll just do
Well, I
whatever
have
we
to
want.
say, in Georgia, we do have to care about case law because our statutory law governing this discussion that we're having is very limited, and frankly, pretty much all of the guidance we have, except for some very general statutes on uh, what are the rules governing or marital property division, all that. We have to look to case law, at least in our state and in a lot of other states, to get our guidance as to what to do. And I mean, that's where Beth's familiar with the Thomas case. And there's another case about Miller that's about goodwill. And that's just what we have to rely on.
Mm-hmm. And I think that go ahead. Beth.
Unfortunately, though, we can name most all of the cases, but we don't have a ton of case law. So we have some really important cases that everybody relies on. But I think other states that are much more prolific in the case law and in what they have coming out, it can give you more guidance. So I think case law can be really helpful because it gives you guidance. We don't have cases that tell us how to do the tracing, which we don't have the guidance, but at the same time, that means that we can make the argument. We can do different things and kind of frame things differently. The titling, that's an area that got hot probably 6-7 years ago. And we got this flurry of cases that were all about titling. So that's kind of one of the reasons we've harped on it a lot, because that's what we have guidance on. But yeah, it's very important to be knowledgeable about the cases and know, because the judges are reading them and they know what they want to rely on. So we have to tell them why you should rely on it or why you shouldn't.
And it I think it has changed over the past couple decades, because the analogy that everybody used to use was, if the three of us all take $1 and we put it in a hat, right? And Beth's dollar is the separate dollar, and Bob's dollar is marital, and my dollar is marital, and we put all those $3 into the hat, then they have been commingled, right? So they've all been put together. We don't know which one's which, but then have they transmuted? So did Beth's dollar transmute into marital money? And it used to be like, if you couldn't figure it out, it was just all marital. Well, I think the courts have progressed into even accepting some of our hybrid ways of looking at it. So I think that in the past, if you didn't have very clear evidence of separateness, then somebody might have said, you're out of luck, right? But now we have a lot of case law that does support this hybrid kind of looking at it. I think mostly because the judges understand and we can all understand, okay, you came in with $2 million. I mean, there should be a portion of that that is still yours, right? Like you didn't contribute it. You didn't have, maybe one of the things, Bob, that people talk about is that it was a gift to the marriage. That it implied when I took that $20,000 out of my separate inheritance and I paid our bills, that there's an implication that I converted that to marital. Isn't that what the court's going to say?
Those are when I interviewed the jurors in a trial I had on that very subject, that was the word they used. We just viewed this as a gift to the marriage.